Yes, Mr. Webb.
Yes, may it please, your lordships, your ladyship. I'm here on behalf of the appellant,
Yes.
Pearson, who sits behind me.
Okay.
Mr. Macur, my learned friend, for the respondent.
Yes.
Summing this up in one sentence, this is an appeal concerning interpretation of the mental disorder description within the Armed Forces Compensation Scheme. Dealing with housekeeping matters first, there are, I would hope, 4 bundles before the court. The first is, certainly in my copy, simply headed Core Bundle, with the case name. That bundle contains, amongst other things, the skeleton arguments from the parties. So mine at 84, my learned friend's at 100.
Yes.
I understand my learned friend has also provided a further copy with updated page references. That's not a bundle. That particular bundle also includes the decisions from the tribunals below. So the first tier tribunal at 68, the other tribunal at 34. There is a further supplementary bundle, as my copy is headed, which essentially contains documentation regarding the permission to appeal process to the Upper Tribunal. I suspect we'll have little recourse to that particular bundle. Mm-hmm. Thirdly, there is an authorities bundle, which simply contains the case of Duncan Williams. I don't think my learned friend and I are particularly part in the meaning of that case, or what it says, but it is there. Then the scheme itself, and then right at the back, a single provision from the Pensions Appeals Tribunal Act. Fourthly, there is what I've called the IMEG bundle, which is a separate bundle that's been put together because of an admissibility issue. My Lord, the issue with IMEG is this. The statutory instrument with which we're dealing was drafted in part, at least, in light of a report from something called the Independent Medical Examiners Group. Their recommendations informed the subsequent instrument. It's not, I say, a central pillar to my argument on behalf of the appellant. It is a point consistent with the appellant's interpretation of the Act, in terms of the way the IMEG suggested these descriptors should be drafted. I think the view of both my learned friend and I is that perhaps the straightforward or most timely way of dealing with this is simply to hear what we say about the IMEG report rather than determining it as a preliminary issue on admissibility. It may be that the court takes the view it doesn't take the argument any further anyway, in which case admissibility falls away. If, however, admissibility does become a more significant issue, perhaps hear from my learned friend and I at that stage. We have both put short notes in the IMEG bundle at the outset, which summarise our position as briefly as possible.
Yeah, thank you for those. And there are really 2 separate aspects to this, I think. One is the principle as to what categories of document may be admissible as an external aid to construction of a statute or a statutory instrument.
Yeah.
And the other is that even if, as a matter of principle, this were admissible, is it really capable of assisting the court one way or another?
Yes.
And without wanting to take you away from submissions you may want to advance, I do just wonder how the mere fact that there's a slight difference between the wording of the recommendation and the wording of the statutory instrument really enables any safe inference one way or the other. Because, speaking provisionally, and obviously subject to any submissions you want to make, it does rather seem to me that the fact of the difference might be explained by Parliament entirely agreeing with the recommendation but choosing to express it slightly differently. But equally, it might be consistent with them disagreeing with the recommendation and wanting to say something different. And I just wonder how merely by looking at 2 documents we're going to be able to say one way or another.
Yes.
So, by all means, pursue the point if you wish, but I think that's an aspect of it which you'll certainly need to assist us with if you want to pursue it.
I'm grateful. So that concerns the documentation. What I would propose to do, and I'm sure I will be sped up if required, is to spend a short time just setting the actual scheme in the context in which it arises, before a brief summary of the particular background to this case which we're concerned today, and then essentially moving through the grounds of appeal in order. I don't know, my lord, whether you've had the opportunity to look at the skeletons.
Yes, I think we've read those, and I think you can proceed on the basis that each member of the court has a good working knowledge of the documents. Obviously, if you want to take us to particular passages, then please do. But in terms of an overall picture of the case, I think we're all pretty well informed.
I'm very grateful for the indication. In that case, I shall move particularly speedily through the preliminaries. The scheme itself, then, the Armed Forces Compensation Scheme, is a no-fault compensation scheme designed to compensate servicemen and women injured or made ill through their service. Its better-known cousin, perhaps, is the Criminal Injuries Compensation Authority and the provisions that go with that. A scheme of this sort has existed in one form or another for many, many years, but gained increasing formality during and after World Wars. Until 2005, there was what's called the War Pensions Scheme. In 2005, that scheme was significantly updated, and a 2005 version of the Armed Forces Compensation Scheme came into being. That was, as is our particular scheme, delegated legislation under the Armed Forces Pensions and Compensation Act of 2004. The draft or version with which we're concerned was, or is, a significantly updated version of the 2005 scheme, updated following a review process in 2010-2011, led by Lord Boyce. That review included input from the Independent Medical Examiners Group, to which we referred a moment ago. We therefore arrive at our scheme, which is the Armed Forces and Reserve Forces Compensation Scheme Order of 2011. It begins at page 26 of the authorities bundle. I don't propose to take you there immediately. How it works in broad terms is this. It's firstly for the service member concerned to establish that they have a relevant condition, and that condition is attributable wholly or predominantly to service, whether that is a mental health condition or a physical condition. There's no dispute as to attribution in our case. Once the condition and its attribution are established, the task of the decision maker is to assess where the condition falls within the various tariffs, and those tariffs set levels of award for differing severity of conditions. I would invite the court just to consider three provisions at this point. Firstly, page 32 of the authorities bundle. You should find towards the bottom of the page Article 5 of the scheme. This is the article giving further interpretive information. It, I hope, is sidelined in your copy, my lord, but...
Yes, very efficient, thank you.
Thank you, I'm grateful. The particular terms, functional limitation or restriction, which is relevant to our particular descriptor, and subsection 5 over the page, at page 33, concerns duration, or what is meant by duration of effect within the mental health descriptor. That is of some relevance to ground 3 of the appeal, which concerns the time frame considered hitherto. The second of the 3 provisions I would suggest we look at this stage is at page 42 of the manual. Should find there Article 16, and I will pause to simply draw attention to 16(1)(b), where an injury may be described by more than one descriptor. The descriptor is that which best describes the injury and effects for which benefit has been claimed. In essence, the task is to determine the most appropriate descriptor. That is, to some extent, codification of the decision in Duncan that was made prior to this scheme. Lastly, then, and most importantly of all, if I could ask you to turn to page 126, we have the provision with which this appeal is concerned, Table 3, mental disorders. And we are particularly concerned with items 1 and 2, items on the left-hand column. The middle column, level 6 or 8, refers to the level of compensation payable. And then finally, the third column on the right, we have the description, the descriptor itself. What we can see is the differences, of course, between severe and moderate functional limitation. I pause to note that A1, the category above the descriptors with which we're concerned, has been inserted subsequently. It did not exist at the time the decision was made in Dr. Pearson's case.
When was it inserted?
2019. Over the page, we have what might be called the flesh on the bones of those 2 descriptors at footnotes A and B, which again I hope are sidelined.
Before we go there, you say that A1 was inserted in 2019 and doesn't apply to Mr. Pearson's case because of it doesn't apply on the facts. There's been no suggestion.
No.
But if it did on the facts, are you saying that it wouldn't be considered by the court or the tribunal?
Yes, it potentially would have been an issue, yes. Do I say it would have been the correct description?
No, sorry. It's just I'm perhaps misunderstood you by saying that because it was a late addition, a late insertion, that it would not be relevant. But in fact, Mr. Pearson's case was considered after 2019, wasn't it?
Well, the initial decision by the Secretary of State, representative through Veterans UK, was made in July 2018.
Oh, I see.
So prior
I understand. Yeah.
It has come into being during the course of the tribunal.
I understand now. Yeah, thank you.
I don't propose to read out the footnotes, but the essence of this whole appeal is what the tribunals, the decision makers, and indeed this court is to make of the difference between those 2 footnotes, with A being the severe descriptor referring to over time being able to work only in less demanding jobs, whereas footnote B, the moderate descriptor into which Dr. Pearson's case has 2 fallen, simply describes able to work regularly in a less demanding job.
So, just taking up what you very helpfully told us a moment ago about item, excuse me, 1A,
Yeah.
Before that was added, footnotes A and B didn't cater at all, did they, for the situation where somebody is rendered completely incapable of work?
Yes, that would be correct.
Right. Perhaps not surprising it was added then.
Indeed, indeed. So returning to the task which the decision maker has to make, once there's a decision as to attribution, once there's a decision as to level within the tariff, what falls to be awarded broadly is firstly a lump sum award, and secondly, in respect of the more severe conditions, something called a guaranteed income payment, which is an annual payment that is made. Those are calculated in this way. Page 151 of the bundle. I hope you'll find table 10. You may recall we looked at numbers 8 and 6 for the descriptors respectively. What they tell us is that the level of award presently stands at 61,800 for a moderate condition, 144,200 for a severe. Those are the amounts corresponding to levels 8 and 6. Those figures are uprated occasionally. That element is relatively straightforward. The guaranteed income payment, which is of relevance to our case because Dr. Pearson does receive it, is governed firstly by Article 24, which is at page 47 of the authorities bundle.
47, did you say?
Page 47, yes. Article 24, if I may. What that says in broad terms is that the guaranteed income payment is calculated by reference to a percentage of final salary. Right at the bottom of the page, we have those percentages. Because, as it stands, Dr. Pearson has an award equivalent to level 8, he is entitled to 50% of relevant final salary. If, in fact, as he says, this is a case that should have been in the severe category, which is a level 6, it would increase the entitlement to 75% of final salary. My Lord, we don't need to go to the table, but it bears mentioning that the calculation is multiplied by a further factor similar to the multiplier in special damages claims. In this case, the multiplier decreases with age. In this case, the multiplier is 0.705. So where you end up is with a calculation of 50% times final salary times 0.705 to land upon the final figure. If you want that reference, or it would assist to have that reference for your note, the table is Schedule 4, which is at page 157 of the authorities book. The last point I make about the guaranteed income payment is this. The guaranteed income payment is inclusive of service pension. You do not get both. So, for instance, if somebody is entitled to a £20,000 guaranteed income payment, if they're already receiving a £10,000 per annum service pension, they simply get the extra £10,000 to take it up to 20 by way of guaranteed income payment.
And does it continue post-retirement age?
Yes, it continues for life.
Yeah.
And did you say the guaranteed income payment is only for certain higher levels of injury.
Yeah. Levels 1 to 11, if I remember correctly. There are 15 levels.
Right. Okay, thank you.
So that is the scheme. The way it's administered is that decisions are made on behalf of the Secretary of State by Veterans UK on application by servicemen and women, whether in service or out. In the event of the service member not accepting the decision, there is a route of appeal to the first tier tribunal, Armed Forces and War Pensions Chamber. Turning then to the specific facts of Dr. Pearson's case, and I do take the court's helpful indication that you are aware of it. Dr. Pearson served in the Navy from August 1990 till November 2017, when he was medically discharged. He was a surgeon commander, an ENT consultant within the Navy. Additionally, he did locum work in the NHS, sat on committees, such as committees awarding prizes for clinical excellence, and he was involved in research. By approximately 2009,
I'm so sorry to interrupt you, but it would help me just to be able to pin down one or two facts.
Yes.
There's reference to in the papers to another role. I'm afraid I can't remember the title. A defence consultant advisor, I think.
Yes.
What does that involve?
Can I just turn my back?
Yes, of course. Yeah.
I'm told it means, in essence, training senior members of the specialty. So, ear, nose, and throat as a specialism, for example. Dr. Pearson's role would be the training of the senior consultants within that particular role, amongst other duties.
Right. And as an ENT consultant, he was presumably carrying out operations, was he?
Yes.
Thank you. Yes, I'm sorry to have interrupted you. That's helpful.
In 2009, Dr. Pearson was diagnosed with a depressive adjustment disorder, attributable predominantly to service, and at risk of putting it too broadly, but in essence, his duties and roles decreased thereafter. His private work decreased. He reduced in about 2014, if I remember rightly, NHS locum work before stopping the NHS work entirely in 2015. There were 2 attempts at a graduated return to work within the Navy, but they were not successful, and so he was medically discharged in 2017. He had been medically downgraded in 2016.
So what does that mean? Sounds rather awful. What does the downgrading involve?
It means downgraded in terms of rank and level within the service.
Right.
Sorry, forgive me. I spoke out of turn. It means the reducing of occupational responsibilities. So the example I've been given is no night work from that point forwards.
Right.
So it's reducing the scope of duties to be fulfilled within the role.
Yes. And then 2017 discharged on medical grounds.
Yes. Those medical grounds being the disorder with which we're concerned. In the meantime, of relevance to this appeal, Dr. Pearson had started sitting as a medical member in the first tier tribunal. It doesn't necessarily matter for our purposes, but I note the first tier tribunal suggested that happened in 2015. I'm instructed it was actually 2030 that Dr. Pearson started sitting. He was.
I'm sorry to keep interrupting, but and you must forgive my ignorance of the role. But what does he do as a medical member? Does he conduct any examinations, or does he simply advise the non-medical members about the medical aspects of the application?
It's broadly the latter. So what happens in the social entitlement chamber of the first tier tribunal is that chamber deals primarily with benefits appeals. So somebody who has been turned down for personal independence payment, for example, will appeal to the tribunal and say, I should have it. That involves consideration of a number of descriptors, so different elements of function. Broadly, half the award is to do with mobility, half of it is that particular benefit is to do with daily living. The tribunal sits as a panel of 3, so a legally qualified judge, a medical member, and what's called a disability qualified panel member. That is somebody with experience of disability, whether it be a physiotherapist or somebody who specialises in the care of those with autism, for example. They may be disabled themselves, but somebody with that branch of knowledge. On an average day in the tribunal, there are about 5 cases with bundles ranging from 100 pages to 500 in some cases, containing medical information, application forms, and so on. The appellants come to the tribunal, and there is a hearing where the panel asks them questions. There is a provision where appellants can be physically examined by the medical member. In my experience, it doesn't happen in reality. So what is conducted is an oral hearing, at the conclusion of which the panel makes the decision as to entitlement to the particular benefit. And as your Lordship helpfully indicated, the medical member's primary role is to advise on the medical aspects. So it is not unusual for instance, the judge to say to the medical member, I haven't heard of this particular condition. Can you tell me about it? What does it generally mean in real terms? How does it tend to affect people?
Yes.
And that's the medical member's role.
Or if the report refers to an increase in a particular level, presumably Mr. Pearson will be able to assist others with whether the increase is a good thing or a bad thing.
Yes, indeed. And perhaps even further, whether what the appellant says is broadly credible in line with their experience.
Okay. So in theory, Mr. Pearson might, as it were, go behind a curtain and conduct a swift examination, but in practice that doesn't happen.
Correct.
But in any event, these aren't ENT cases, I take it. They're just all cases.
They
all kinds of cases coming
any
forward.
medical condition that somebody indicates or argues would entitle them to benefit.
Yes. So, if I could just ask this question, no doubt Mr. Pearson will be able to give you the answer very quickly. When was the last time he conducted any surgery as a consultant ENT surgeon?
If I might just turn.
Yes.
Thank you. Around 2015, 2016.
Right. So around the time the medical downgrading.
Yes.
Yeah, that's really helpful. Thank you.
The tribunal work, therefore, has been ongoing for about the last 10 years. The obligation on the medical member is to sit for at least 15 days per year I speak from experience in saying there is a desperate shortage of medical members. So in reality, Dr. Pearson sits on average once per week. And those are in his local centres, which happen to be Havant and Southampton. At the point of decision in his case, the first tier tribunal was and remains his only employment.
And given the shortage, presumably, if he felt able to do it, he could sit several days a week.
Yes.
In various locations further afield than those he actually visits.
Yes. Members are appointed to regions
Yeah.
broadly like the circuits we know of in the court system. Dr. Pearson is in the Wales and South West region, which covers Devon, Cornwall, Wales, all the way over to Portsmouth, effectively.
Yes, thank you.
Has he, Mr. Pearson, since 2013, we know has had to reduce his sphere or his region by, as you say, Havant and Southampton. Previously, when he first commenced sitting in the FTT, was he sitting throughout that large region? Wales and the South West?
I suspect the answer is no, because there was no need. But perhaps again, if I might just turn my back to make sure I'm getting that right. So the answer is, in the early days, sittings were fewer because of the fact that Dr. Pearson remained engaged with the Navy, so he had less time for the work. Even so, he's never gone further than Aldershot, he says, which is, forgive me, I may be telling you what you know already, but it's sort of North Hampshire.
Yes, but there's obviously been a reduction as things have become more difficult
Yes,
for him.
he doesn't go to Aldershot.
Yes, so he now is a very limited
Yes,
area.
just Havant and Southampton.
Yeah.
Resuming, if I may, the journey then through the background. On his discharge, Dr. Pearson applied for an award under the compensation scheme. In March of 2018, the Secretary of State accepted that his was a mental disorder attributable to service. If I could trouble the court to return to the core bundle, that's the one with the sentences and the decisions. At page 77 of that bundle, you should find a page with the Ministry of Defence logo in the top left-hand corner. That is the decision made by Veterans UK at the outcome of the paper process. It doesn't provide much by way of the reasoning, which is no criticism, that's simply the way the scheme works, but it confirms that initial placing of his case in the moderate descriptor.
But we note that in the further information right in the middle of the page, it is said that the onset of Mr. Pearson's condition is approximately 2009.
Yes.
So that's equating onset with first seeking specialist advice.
Yes.
Broadly speaking.
Broadly, yes. Over the page at 78 is confirmation of the guaranteed income payment. You'll see that initially, at least, when the maths came out in the wash, there was in fact no extra payable to Dr. Pearson. That did change at page 80 of the bundle, following perhaps a recalibration, if I can put it that way, so that there was a modest excess, just over £4,000 that became payable.
Was the application purely on paper, or did Mr. Pearson have to attend an interview or anything like that?
It's a paper process,
Right.
there can be psychiatrists' reports, things like that, included within the process, which is what happened here.
Right.
But they tend to be from treating doctors. And obviously the Army has all the medical records of the servicemen.
Thank you.
Following the decision of Veterans UK, who, as I say, administer the scheme on behalf of the Minister, Dr. Pearson pursued his appeal to the first tier tribunal and thereafter the upper tribunal, arguing that his should properly be considered a severe condition. His appeal was dismissed by each of those, with a key finding, if I can put it that way, that because the tribunal work was regular, he therefore fell within moderate functional limitation because of the very reference to the word regular within the footnote to that descriptor. The decisions below, firstly the first tier tribunal decision, begins at 68, but for present purposes perhaps I could ask you to turn to page 73. The key paragraphs I would suggest are 29 and 30. I don't propose to read those out, but as I indicated a moment ago, the tenor of those paragraphs is that regularity was the key to the decision here.
Yes.
That decision in turn was taken to the upper tribunal, beginning at page 34 of the core bundle, but perhaps I could ask you to turn to page 39 for present purposes. The upper tribunal agreed with the first tier tribunal's approach to interpreting the descriptors. Paragraph 26, towards the top of the page, enshrines that decision that regularity is indeed the figure or the feature that holds the key in the upper tribunal's judgment. Perhaps invite the court to read through to the end of paragraph 31, as those are the key paragraphs.
Yes. In particular, we see at paragraph 29 the judge's view that once the first tier tribunal had determined, and as he later says, justifiably determined that the work was regular, that was the end of that.
Indeed.
The tribunal was compelled to conclude that item 2 applied.
Indeed. And my lord, you'll have seen from the skeletons that the word compelled is of some significance on the appellant's case and is wrong in law.
It's rather surprising, isn't it, that in paragraph 27, the upper tribunal refers to the decision of upper tribunal Judge Whiteley in SSWP against MG. as a protean one, so taking its meaning from its context, and then seems to undermine that in the subsequent paragraphs.
Yes, exactly. One of the difficulties with these provisions is quite how one pins down what is meant by regular or regularly. And that, the appellant says, is one of the very reasons why the severe descriptor is measured rather by trajectory of work rather than regularity, or at the very least is measured by an element of both, because that assists in having something solid and tangible to which the decision maker can cling.
Well, it's the whole picture, isn't it?
Yes.
Against which regularity has got to be assessed.
Yes. Indeed.
I'm sorry to talk across you, Mr. Webb, but it seems to me, looking at paragraphs to which my lady has drawn attention, that there are really perhaps two stages. One is to decide whether a particular pattern of work can be described as regular. And so there's discussion, for example, the person whose job only requires him to work once a year. But what perhaps isn't really addressed is the situation where the work can properly be described as regular, but can also, on the face of it, properly be described as falling within item 1, whatever precisely item 1 means.
Yes.
Because there does seem, speaking for myself, to be quite a substantial measure of overlap between these two items.
Yes.
I think, if I may say so, you put it very elegantly when you said they don't flow naturally from one to another.
Yes.
The visible difference between them is, on the face of it, really very little. There must be more to it than that, really, since otherwise one's never going to be able to decide how to categorise a particular claim.
Yes, indeed. And it is that process of striving to find the consistent thread that runs between them that the appellant says has led the learned judge below and colleagues before him to fall into error. Maybe that's an opportune moment to turn to the skeleton argument, which mine begins at 84, but perhaps page 85 is a useful stopping point. Find there is the essentially grounds of appeal in outline.
Yes.
And grounds 1 and 2 are, of course, very closely related. In essence, it's the appellant's contention that regularity is either no part of the test of a severe descriptor, or if it is a part of the test for the descriptor, it is nonetheless not the sole distinguishing feature between severe and moderate. And that very much comes back to the word compelled that we looked at earlier. Because the appellant says no, in fact, even if there is some regularity of work, the decision maker is not compelled to find that the severe descriptor cannot apply. The third ground, to some extent, really flows from the outcome of grounds 1 and or 2. Because if you are with the appellant that trajectory or pattern of work from the onset of illness is a relevant consideration, then it must follow that the task of the decision maker is to consider the history from the onset of illness.
And that could work both ways, presumably.
Forgive me, my lady, in
In the sense that looking at the period as a whole, your argument accepts the possibility that the tribunal could find that there had been an improvement as well as a disadvantage, a further disadvantage displayed, so that it doesn't all point one way. It's again saying that the relevant decision maker, whether it be the veterans or the tribunals, have got to be flexible about this and have a wide-ranging gaze.
Indeed, absolutely, my lady. Absolutely, it could work against an individual as well as for them, if in fact the trajectory is upwards. I accept.
Yeah.
The skeleton addresses ground one, beginning at page 89. And as a reminder or stopping point, what we're considering is two descriptors that are materially the same, one for moderate functional limitation, one for severe. The difference between them being set out in the footnotes. The more severe saying, and over time able only to work in a less demanding job. The moderate saying, but is able to work regularly in a less demanding job. And the appellant's primary contention is this: the starting point in any exercise of interpretation is simply to look at the wording itself. If it assists, page 87, 2 pages back, the descriptors are set out as other footnotes in the skeleton. And what you may feel stands out immediately is that footnote A, for the severe descriptor, makes no reference to regularity or indeed lack of regularity at all. And that, in the appellant's contention, immediately raises a question mark as to whether it can be said or interpreted as being a descriptor that is concerned with regularity. What, perhaps, is the more obvious reading? Well, certainly in isolation at least, the appellant would suggest the more obvious reading is that this is talking about a declining trajectory of work over time. Why is that problematic? Why does it lead us to this court? Well, because, as my lord has pointed out, it doesn't obviously flow from the moderate descriptor. It might seem odd that the two descriptors are talking about different measures of functional limitation. And it is the process of striving to find that common thread that has led us to the point where regularity has come to be defined or set as the distinguishing feature. My submission is that, first and foremost, we don't need a consistent thread to run between descriptors. If I could trouble the court to go back to Article 16, which is at page 42. Page 42 of the authorities bundle, Article 16. The provision we looked at a little earlier, where an injury may be described by more than one descriptor, the descriptor is that which best describes the injury and its effects, and so on. We wouldn't need Article 16 if there were never the possibility that a condition may potentially fall into more than one descriptor. The fact is, I say, that the scheme recognises the potential for overlap, for difficult decisions. And because of that, there isn't a need for a consistent thread to run through the levels of descriptor. They are simply talking about different things. Whether regular work within the moderate descriptor is the more compelling factor in any given case, or whether in fact the trajectory of work is the more compelling factor, simply links back to which is the best fit in any given case. They don't have to deal with the same aspects of somebody's condition. And there are, in my submission, aspects of the plain wording of the footnotes that lend further weight to that contention. So perhaps if we could visit page 127 of the authorities manual again, simply because that's where the footnotes are set. Noted in passing the fact that the word regular or non-regular is not within the severe descriptor. As you may have read that the Upper Tribunal placed some significance in the omission of the word regular. What it didn't do was consider any other explanation as to why the word regular may not be there. And the appellant says it's not there because this descriptor isn't about regularity. Secondly, the footnote A descriptor talks about the very last word, less demanding jobs in the plural. Footnote B descriptor talks about job in the singular. Now, I of course accept there is a broad rule that the singular includes the plural and vice versa. But why might there have been a choice with these descriptors to draft them differently in that way? One explanation, I say, is that the severe descriptor is talking about a pattern over time. That's why it is in the plural. It is consistent, in my submission, with the appellant's contention as to the proper interpretation. What else on the wording might lend some support? Well, elsewhere in the tariff, at one point, where lack of regularity is a factor, the scheme says so. And conveniently for us, it's in the very next table. So 127 goes on to table 4, physical disorders, illness, and infectious diseases. In particular descriptors that apply here are item 3, column A, level 9, physical disorder causing permanent, severe functional limitation or restriction. And item 1A, physical disorder causing permanent, very severe functional limitation or restriction. I pause simply to add that 1A in this descriptor was added in 2014, so it was before the decision in Dr. Pearson's case. although we're not talking about moderate and severe, we're talking about severe and very severe. The footnotes are very similar, and those are at 1 to 8. The last two footnotes above table 5. Pause just to allow those to be read. What we have is the severe, so the lesser of these two descriptor very closely mirroring the severe descriptor with which we're concerned. It does, understandably, given its context, include reference to physically less demanding jobs, but otherwise the wording is the same. If we then look at the very severe footnote, the middle of this time, there is reference to undertaking work only sporadically. You might think it is odd that where lack of regularity was deemed to be a relevant factor in the physical disorders and illnesses table, those drafting the legislation, I should say, expressly said so by using the word only sporadically.
Can you remind me again when that was inserted?
2014.
Right, so before the 1A was inserted into the table that we are actually concerned with?
Yes.
Yes, so 2014.
So 5 years before 1A in our table, 4 years before the decision was taken in Dr. Pearson's case. So it was in existence at the point the decision was made.
But I wonder, Mr. Webb, whether again we're seeing here in Table 4 a similar problem to the one you've been addressing us about in Table 3, only the other way round. Because looking at the last footnote in Table 4, over time able to work in only physically less demanding jobs, I suppose it might be said, but perhaps those physically less demanding jobs might only be sporadic. The middle footnote talks about sporadic and physically undemanding. The third one talks about less demanding. So again, it's perhaps an illustration of one of the points you're making, that these footnotes may not be stark opposites, so that if you come within the terms of one, you can't come within the terms of the other.
Yes.
It's more a search for which is the most appropriate descriptor in the particular circumstances of the case.
Indeed. Indeed. So again, coming back to the Upper Tribunal's emphasis on the omission of the word regular from our footnote, placing some significance in that, it might just as equally be said, well, the omission of the word sporadic, given it appears elsewhere in the scheme, is of equal or greater weight in interpreting the provision. The fourth and final point I make on the plain wording is this. If the tribunals and the decision maker to this point have been correct, and the distinguishing feature between these descriptors is regularity of work, then what does the phrase "and over time" in the footnote to the severe descriptor add? So back at 127 with our footnote. As we've discussed, the phrase "and over time" is the only obvious change in the wording from the footnote below it. It becomes totally meaningless if there is not some aspect, at least, of trajectory within the task of allocating the correct descriptor. If the only difference were that non-regular work is what makes the condition severe, it would be much easier just to say that. But it doesn't. And the appellant says that's because it's not what this descriptor is about. Straying, if I may, into hypotheticals, the respondent, and to an extent the tribunals below, raises what we might call a conceptual difficulty here in how to apply these. And it's rough and ready, but hopefully serves to illustrate my point. If we take levels of demanding work and grade the most demanding as level 1, the least demanding as level 5. Of course, in reality, it's not that straightforward, but broadly speaking. If we take two individuals who were both capable of level 1, so the most demanding work there is, until they became ill, who can now both work level 5 only, but regularly. So they have dropped to the bottom of the chain. If one falls straight away from level 1 to level 5, that would appear on the appellant's contention to place them within the moderate descriptor. What if the other individual starts from level 1, tries level 2, 3, 4, before finding him or herself at level 5? In that case, there is the trajectory the appellant talks about. Does it mean, if I am correct in my argument, that the latter should be treated as severe and the former as moderate? Because that would seem unfair when they both reached the same endpoint. Well, the answer in my submission is possibly, because that is what the scheme says. But perhaps more sensibly, this brings us back to Article 16. That is the task for the decision maker. In that given case, with those individuals, which is the more compelling factor? Is it the trajectory or is it the end point? That is the decision they have to make. They cannot, in my submission, simply say they are both now working regularly in a less demanding job, and that is the end of it. That is the error.
Mr. Webb,
Yes.
may I ask a point of information?
Yes.
Is this a once and for all award, or is it possible, in the example you've given of somebody falling gradually from 1 to 5,
Yeah.
once they hit level 5, to go back and say, I'm afraid that when you made the decision, you may have been right to say that I was at level 3 and then put me
Yeah.
into a moderate category, but now I'm at level 5 and all the circumstances point to this being severe. Is it possible to redress that?
My recollection, I'm just looking at the provision, my recollection is in exceptional circumstances it can be reviewed. So it is not necessarily the final stage or the final curtain, as it were, on the award. So Articles 53 through 59 deal with the situation, my lady, that you raised. So beginning at page 74.
And on a similar theme, is there any time limit in which a serviceman must make the application?
Yes, there is. The time limits are provided at, forgive me, thank you, I'm grateful to my own friend, provision 47 onwards. The long stop generally is 7 years from discharge. I'm grateful, yes, page 70.
Right, thank you. And 49, it looks, 47 or 49, can be extended for such further period.
Yeah. So there is a discretion.
Yeah. And then, forgive me, so an interim award can be made if prognosis for injury is uncertain. That's 52.
Yes. So,
And reconsideration 53.
Yeah. And in fact, there was an interim award in Dr. Pearson's case. He was awarded £10,000.
Yeah.
It then falls to Veterans UK to revisit within a year or two and make a final decision. Effectively, it allows a little more time for things to play out.
So, having that in mind now, the answers to the last questions I posed, does that impact upon the example you've just given about trajectory?
It could do. It could do. But if we are assuming a hypothetical situation where the trajectory has reached that endpoint at level 5 by the point of the decision, that extra time, that potential for revisiting, isn't going to change anything in the hypothetical that I proposed.
But it means that in that case, if both individuals have reached level 5,
yeah,
whether immediately or gradually, their claim is based at the same point. They've reached level 5. So the answer to the question, does that mean that the latter should be treated as severe and the other as moderate? Would that necessarily come into play?
Well, it depends. I suppose what we could do is add levels 6 through 10 and an even further fall. And what if the person who dropped straight to level 5 then starts to sink a little further on a trajectory? Then yes, potentially reconsideration may say, actually the trajectory has gained speed or sunk further. And so in that particular case, trajectory may indeed be the winning factor, if I can put it that way.
But this trajectory argument actually does not undermine your first point in any event, does it? The regularity issue.
No.
Trajectory is your ground 3.
Yes, so that comes into the consideration of the period, so the evidence to be taken into account.
And also, it's part of the footnote that you've referred us to.
Yeah.
Over time, because at whatever point in the trajectory, if it's downwards, then there's an indication of less demanding jobs.
Yeah.
At whatever stage you reach, it's going in one direction only.
Yes.
Okay.
Mr. Webb, before you move on, can I just check I've understood about reconsideration of decisions, etc.? Just quickly turning the pages as you've been answering my lady's question. If we look at page 74 in the authorities bundle, I'd like to check I've understood the broad scheme here. Page 74, Article 53, reconsideration. That, I take it, is where a claimant says, in effect, I'm dissatisfied with your decision, could you please look at it again?
Yes.
Then, foot of page 75, 54, Article 54, finality of decisions. 54.1, no review of a decision except in the circumstances specified in 55 to 59.
Yep.
So looking at what those are, 55 is where the claimant has subsequently had his or her service terminated.
Yep.
56 on page 78 is exceptional circumstances arising within 10 years. 57, it goes with 56 and is the finality of that review. 58 is a review going the other way, where a sum has been awarded and the Secretary of State subsequently discovers that there should have been a deduction made in relation to benefit, so that deduction can belatedly be made.
Yeah.
And then 59 at the foot of page 80, a review of a decision where there was a mistake as to law or ignorance or mistake as to a material fact.
Yes.
So assuming no mistake as to law, no significant mistake as to the facts, the review is really only going to arise in practice where there are the exceptional circumstances within 10 years or termination of service.
Yes.
And exceptional circumstances, no doubt, we'll find a definition somewhere if we look through, but presumably they have to be truly exceptional, not just,
Indeed.
well, we hope this wouldn't happen, but it has happened, so please may I now apply again.
Yes.
Yeah, okay. Thank you.
And in part 56 or article 56, whichever it is on page 78, the injury at 3b has to worsen or develop in an unexpected and exceptional way. So it's not merely the fact that the prognosis has proved inaccurate and things have got worse. It's got to have got exceptionally worse.
Yes, absolutely. Perhaps a minor wound on a foot, say, that becomes infected and leads to amputation or something like that, when that wouldn't have been expected. So the recourse to a further decision from the Secretary of State is very limited, albeit, of course, not impossible. If I might just return to one example on the hypotheticals, if we take our grades 1 to 5 again, I say even on the respondent's case, there are anomalies or oddities. If we take somebody who starts at level 4 and drops to level 5 working regularly, we call them person A. Are they to be treated the same way as somebody who starts at level 1 and slowly drops to level 5? Call them person B. Because if all we're talking about is regularity, that is a result that is just as unfair or odd. They will get the same compensatory award, they will get the same guaranteed income payment, despite the person who's dropped from level 1 to level 5, in all likelihood having been a higher earner working in a more demanding job. That is why I say trajectory matters, because in that case, one can well imagine that the decision maker might take the view that for person B, who's tumbled from 1 to 5, trajectory is the more compelling factor than regularity. There are, I'm sure, other examples we could consider, which would be an interesting academic exercise, but I suspect wouldn't take us much further. But what I do say is that leaves us in a position where not only does the plain wording point away from regularity as the distinguishing feature, but actually it's entirely understandable why regularity should not be the sole or only distinguishing feature. If we apply that to Dr. Pearson's case, no dispute that he's in a less demanding role. The appellant says the question for the decision maker in the tribunal should have been which of the footnotes is most applicable. Is the deciding factor the regularity of the work, which is once per week week, but certainly less regular than 3 days per week? Or is it the trajectory, i.e. falling from ENT consultant to 1 day a week in the tribunal? Either of those might be a legitimate decision on the fact, but the error is in failing to ask the correct question. That leads to ground 2, which really is very, very closely related, which is that either ground 1, regularity, is no part of the task for the first descriptor, for the severe descriptor, or ground 2, if it is some feature, then it is nonetheless not the sole distinguishing feature. The reason the grounds fall to be separated as I have done is because of the decision of the Upper Tribunal and the learned judge there. My Lord, you've already pointed out the word compel. There is further reference, if we could turn to page 43. Paragraph 46 by the lower hole punch. The same point made again, phrased perhaps differently in the last 2 sentences. Once it, meaning the tribunal, had determined that item 2 applied, that was the end of the matter. As long as item 2 applied, item 1 could not. That, the appellant says, is a further illustration and compounding of the error. Of course, the end point is to reach a decision as to which is the best fit. But there is every reason to accept that there can be overlap. Possibly fitting into one does not mean it cannot fit into another. I would further add that the appellant's case restores function to the phrase "and over time" that we looked at in a way that is relevant. And even if I am wrong and regularity is some part of the text, the phrase "and over time" still has a part to play.
Well, Mr. Webb, it would be better, wouldn't it, that the tribunals, the decision makers, should not be hung up on any one particular phrase, in this case, regularity.
Yes.
Because life is far more complex than that. So someone who had been an ENT surgeon could, in the case of a very severe disability, continuing disability, still be managing a very lowly, skilled job.
Yeah.
5 days a week, just for an hour or whatever. I mean, is it perhaps dangerous to push the regularity point? It may or may not be, as you say, a significant factor, but
yes, absolutely. And to some extent, the difficulty in pinning down what regular actually means is all the more reason to suppose that the net needs to be cast a little wider than that. And, well, as you say, we're looking at a broader picture here in terms of capability of work.
well, we're going back to the protean bed, aren't we? Proteus's bed, because you've got to look at all of the circumstances to know whether you've got to cut the bed shorter or not.
Indeed. At this juncture, it falls to me on the IMEG point, and I absolutely take on board my Lord's earlier indication on this. So what I'll do is keep what I have to say about it short. The independent medical examiners group was appointed to advise on medical aspects of the scheme, including mental disorders. And there are, in my submission, two relevant aspects to the scheme. And if I could ask the court to turn to page 16 of what I'm calling the IMEC bundle.
This is the executive summary.
Yes, I'm grateful. And in particular, numbered paragraph 2 towards the bottom of the page tells us about the themes and principles informing the recommendations. So the background, the context to which this report is formed. Paragraph 2 makes plain, if it were needed, that in particular the guaranteed income payment element of the scheme is designed to compensate for loss of employability. Why does that matter? It matters because our hypothetical of someone at level 4 falling to level 5 versus someone at level 1 falling to level 5, it's likely that the level 1 to level 5 has sustained a greater loss of income or potential income by virtue of starting from a higher point. So in the context of the purpose of this scheme, it might seem correct that that individual would therefore receive a higher level of guaranteed income payment.
Do you need this report to make that point?
Well, the difficulty is that the scheme itself does not expressly say that the guaranteed income payment is designed to compensate for loss of employability. If the court is in a position to infer that, and I suspect it may well be, then no, we don't need the IMEC report to make that.
Well, you've already indicated that it's not additional to any pension, so it obviously is intended to compensate for lack of earnings.
Yes.
And that's why it's got the variant provided by the schedule, the 0.7, 0.05.
Yeah, the multiplier,
yes.
table 10, I think. Yeah.
Yes. So on that basis, do you need this report to make the point?
In light of my lady's comments,
I'm only speaking for myself, but it seems to me that you're kind of going a way about it that's not necessary. You're entitled to ask us to infer that, I think.
Indeed. Well, that is the height of the point in terms of policy or background. So I'm grateful for the indication. I don't need to say any more about it in that case. What is, I think, more controversial about the IMEC report is if we look at page 62 of the IMEC bundle. We have a page within the report's conclusions, discussion of mental health disorders. At the bottom of the page, the very last subparagraph is the proposed wording IMEC suggested for severe, so for our descriptor that the appellant says should be applied. And it includes that word increasing, a word that disappears from the final scheme. My lord, I think you've taken the point already that essentially what the appellant says is, well, that is further consistent with trajectory being the matter at the heart of this descriptor. I take the court's indication as to concern, if I can put it that way, as to the extent which this is an aid to interpretation. The only answer I give to that is at page 68. You'll find the explanatory memorandum to the Armed Forces Compensation Scheme. And again, sideline relevant points within the memorandum where the appellant says there is an indication that the recommendations of the IMEG were accepted. The difficulty for the court, and indeed for me, is that there's no parliamentary or other material that explains the omission of the word increasingly. And as has been pointed out at the outset, it potentially cuts both ways. It can either be inferred that the word has simply been missed by mistake, and it should be there, or it might be inferred it was left out for a reason.
Or it may be inferred that it was unnecessary.
Yeah.
Maybe inferred it was unnecessary. We just don't know.
Somebody might say syntactically, less demanding jobs conveys the notion of each job being less demanding than the one before it.
Yes.
So syntactically, grammatically, one may not need increasingly.
Yeah.
But as I said before, Mr. Webb, I don't want to take you out of arguments you're keen to pursue, but it may be that this is not at the heart of your argument.
It's not, my lord, and I do take the court's indication. So, in the circumstances, I won't say anything more about it.
It does seem to me that somebody could argue that goes against you. Increasingly less demanding jobs. So, over time, you can do less and less of kind of job. Well, the claimant, the appellant, started sitting in the tribunal in 2013 and still does. So the less demanding job that he does, it's not becoming increasingly less demanding, it's the same.
Yes, although I suppose what the appellant would say is that's because the tribunal is his end point. That's the end of the trajectory. If we, and ground 3 considers this in a moment, take onset of illness as the starting point, as the jobs he fulfills have fallen away one by one to reach the end point of the tribunal, he still has met that test of an increasingly less demanding job, step by step over time. But I absolutely take the court's indication. That, I think, allows me to move, with the court's leave, to ground 3, which is the shortest of grounds. And what the appellant says at ground 3 is that the tribunal at the first tier and in the upper tribunal fell into error in that they adopted too narrow a time period when considering the evidence of work. The appellant, as we've discussed this morning, says what's required is an assessment of work function at the onset of illness. That's the only way to measure the trajectory. And frankly, I don't wish to take anything for granted, but if the court is with the trajectory is at least some part of the descriptor, then it really follows that that must be right. There'd be absolutely no justification for limiting the consideration to the point of discharge onwards.
Well, in fact, you'd say that the Veterans UK decision was correct because they said 2009.
Yes, precisely.
Yes.
And there's no better reason or support, I would suggest, for that solution than the wording of the footnote itself, which is again at page 127 of the authority bundle. We look at footnote A. functional limitation or restriction is severe, where the claimant is unable to undertake work appropriate to experience, qualifications and skills at the time of onset of the illness, and over time able to work only in less demanding jobs.
And this scheme does apply to serving personnel as well,
It does.
which then makes that very, very clear.
Yes, precisely. So the descriptor plainly envisages in my submission the evidence to be considered is that from onset the decisions below, I don't propose to go to the entries again because we've looked at them already, but essentially held that was irrelevant because what was being considered was the regularity of work at the time of decision. In essence, what was being said below was, well, you're doing the same thing you were doing at discharge. So actually, that is how regular your work is. That's all we need to look at. The appellant says that's wrong because where trajectory comes into it, as he says it should, it has to begin with consideration of what the individual was capable of at the onset of illness. Insofar as it's referenced in the decisions, and so I propose very briefly to take the court to it. The very back of the authorities bundle, page 172, a single provision from the Pensions Appeal Tribunals Act that possibly explains what the court may regard as some confusion below, and explains why there's a difference between the decision maker, who of course is not subject to this provision, and the tribunals below, why there is the discrepancy. It's because what section 5b says is the tribunals should only consider evidence that was effectively known to the decision maker. And there's good logic behind that. It would be somewhat unfair or improper for a tribunal to take account of something else that happened after the decision to say, well, the decision maker got it wrong. So that's well established in law. And it may be that that explains why, as I say, the tribunal got rather waylaid by this point. It's confusing two different matters. It's confusing the ending points of the evidence against the starting. Yes, ma'am.
I was just going to observe that in the end, the decision maker or tribunal has to determine whether this particular claimant has suffered a severe functional limitation or a moderate functional limitation. And I must say, speaking for myself, it seems to me that one can only consider that by looking at the baseline of how he was before the onset of the illness. To start the clock 7 years later would seem to dictate the inevitable outcome that
Indeed.
it was only moderate when, looking at the whole period, it may be severe.
Indeed. As soon as the door was closed to trajectory as a relevant consideration, it inevitably brought the door closed on the time period for consideration, because all the tribunal was looking at was regularity of the less demanding work. The appellant had reached the end point of his work trajectory at discharge. So one error led directly to the next.
But even without trajectory, I just wonder whether you need to rely on trajectory, because going back to the core task, which of the descriptors is the more appropriate in the circumstances of this case?
Yes.
Even if you were just focusing on the words in footnote B, able to work regularly in a less demanding job. Speaking for myself, I don't really understand how you can assess that if you ignore 7 out of 9 years.
Yes, absolutely. And of course, that goes not only to assessing regularity, but the less demanding nature of the work.
Precisely.
So,
All right. Well, anyway, that's that.
my lord, those are my submissions, unless I can assist further. You'll have seen from the skeleton some proposals as to way forward should the appeal be allowed.
Yeah, should we just, simply because you're on your feet, and we'll do the same with Mr. Macur when he gets to this stage in his submissions, but so that we have everything together, can we just see, it's your skeleton page 15, isn't it?
Yes, 19.
Desired result. You invite us, if the appeal succeeds, either to make the decision ourselves, in effect,
Yes.
or remit to the first tier tribunal. You encourage the former.
I encourage the former in the sense that it is quicker and finally disposes of matters. Equally, I do fully accept that if the decision of the court is that the net has not been cast widely enough when making findings, then the likely outcome is that it needs a rehearing to cast the net as widely as it should be.
And this would accord, wouldn't it, with Duncan, that we should pay particular regard to the expertise of the tribunals.
Yes, it does. So I fully acknowledge the wind may be blowing in a certain direction.
All right. Anything else, James?
No, thank you.
No, that's very helpful. Thank you very much. Yes, actually, I should just check. Is everyone okay to carry on for the next hour or so? Yep.
Yes,
Good. Yes. Right,
I
Mr.
need
Magdal.
to check with my client.
Yes, of course. I think he was nodding.
Thank you, Andrew.
Yes. Mr. Magdal.
Thank you, my lords, my lady. I'm grateful to my learned friend who I think has taken you to a lot of the relevant material. I'll keep this as brief as I can. I intend to deal with it in 3 parts. Firstly, to address you on the provisions and the respondent submissions as to how they should be interpreted. Secondly, to then apply that to the tribunal's decisions. And then thirdly, and very briefly, just something about the IMEG report. So if I start with some general observations on the scheme, and it's helpful, I think, to look at the guidance that this court has given us previously in the Duncan case. So I'll start with that if I may. I think most of this is in my skeleton, so I'll take it quickly. But if you have the authorities bundle, you could turn to page 3.
Could you remind me where your skeleton starts again, please, so I can keep an eye on both?
Yes, I have it separately. 100 of the course. Page 100.
Thank you.
The Duncan case is the only case that either of us is aware of that gives any guidance at the moment. And Lord Justice Elias, page 3, paragraph 2, emphasised that the aim of the scheme was to provide a fair system that was easy to administer and, unlike previous schemes, would allow compensation to be paid while the individual was in service. And then paragraph 3, he emphasised that although the initial decision is made by laypersons appointed by the Secretary of State, it's therefore important that the scheme should be, quote, relatively simple. But then secondly, he goes on to say that in making decisions, a vitally important element is the medical information. And then the third point that I take from that is in paragraph 4, that he emphasises, as does Lord Justice Carnworth, that appeals go to a specialist tribunal that has, quote, extensive specialist experience and expertise in handling at this point service pensions claims under the previous scheme. So it is, of course, this is an appeal from 2 specialist tribunals. Moving forwards in the judgment at paragraph 23, which is at page 6 of the bundle, an obvious point that's there for us that in the structure of the scheme, in each table, they are set out in a way where the most serious injuries are at the beginning, and they then descend in order of severity. I'll come back to that. And then, moving to paragraph 47, at page 11 and onwards. This is really relevant to ground 3. There's discussion as to the date for determining the injury, and this is principally in this appeal in the context of whether exacerbations result of medical intervention should be taken into account, and if so, how. But the Upper Tribunal had said that as a matter of principle, the starting point for all descriptors can only be the claimant's overall condition at the date of decision. There was some objection to that from the Secretary of State. It became clear, as you'll see from the second half of paragraph 47, the Secretary of State's position was in fact the decision maker must take account of all the evidence available to him or her when determining the nature and gravity of the injury. This court went on to endorse that. And then at paragraph, so just over the page, the second half of paragraph 48 makes the point that it sometimes won't be possible to make any sensible assessment of the injury at the time it occurs, and it might emerge gradually over time. Any decision maker should make the assessment on the best evidence. And then at paragraph 50, the final sentence, there's a summary that what the Court of Appeal said the Upper Tribunal intended is no more than that all relevant evidence actually before the tribunal should be considered when assessing which injuries were caused by service and what their actual and likely trajectories were. Moving forwards over the page 13, paragraph 53 makes some points about how trajectories may alter in different cases. But paragraph 55, I wanted to highlight because the court accepted, and this was in the context of trajectory and the date that the decision is made. The point, I think, is a general one, that the scheme will result in certain arbitrary distinctions. But then it finishes by saying that that's the consequence of a scheme which enables people to pursue their claim quickly, and points to the mitigations that you've been referred to, whereby in an exceptional case, the final award can be reopened. On the same page, the court then addresses how the relevant descriptor should be chosen. There was some criticism of the Upper Tribunal having an unnecessarily complex approach. They agreed, and this, as my learned friend says, foreshadowed the provision in the current scheme, that the objective is to identify the single descriptor most accurately identifying the injury. You'll note at paragraph 57 that there was some discussion of whether it was legitimate to cross-refer to other parts of the scheme, which I mentioned because you were taken to other parts of the scheme, and the answer from this court was that they discouraged it, but didn't say it could never be permissible. They said the whole purpose of the scheme is to fix sums by quite detailed and precise rules which can be readily interpreted. The appropriate descriptor will be in many cases relatively easy to determine. Indeed, no justification in looking further. And then a final point in that section of paragraph 59, the court made the point, perhaps obvious, that it would not be legitimate for a decision maker, tribunal or Secretary of State, to distort the application of the scheme by trying to identify what seemed to be an appropriate amount or an appropriate award, because the most appropriate descriptor results in what they perceive as inadequate or inappropriate compensation.
Yeah, well, that with respect is plainly right, but that's not the same as saying that the decision maker is to focus on the footnotes to the exclusion of the actual descriptors.
No,
There must be scope for the decision maker to step back and say, well, how have I ended up with the conclusion that this is a case of severe restriction when it's not severe at all? Or how have I ended up with the conclusion that it's moderate when clearly it's severe?
Lord, I wouldn't disagree with that. The footnotes are not the descriptors.
No.
The descriptors are the descriptors, and the footnotes are there to give guidance to those who are trying to decipher the scheme.
To spell out its essential simplicity.
Yes. And I don't think I need to take you to the other paragraphs, but just to point out that at 113 at the end of the judgment, Lord Justice Elias made the point that if the court had misinterpreted what the government had intended, it was open to the makers of the scheme to revise it.
Yes. Just as a matter of interest, and if you're able to help us, how many of these appeals to the first tier tribunal are there? Are there hundreds a year, scores a year, hardly any?
I don't know the answer to that. I can try and get the information.
Yes, I'm not asking for precisely. I'm afraid it's my ignorance again, but I just have no idea whether these issues are cropping up day in, day out, or whether actually such an appeal is a comparatively rare creature.
My learned friend may be in a bit better position to know. I'm aware of some.
Yeah.
My involvement.
I don't know the figures. I would be surprised if it were hundreds reaching the tribunal. The chamber within the first tier tribunal system, which deals with these cases, is very small. There are very few judges.
Right.
So, it is relatively rare.
And that's helpful. Thank you.
I'm grateful. And just to give you the references, Lord Justice Carnworth emphasised 117 that simplicity is the aim, albeit he recognised that it may not have been achieved. And at 120, he endorsed the point that I'd taken you to, that the tribunal is a specialist fact-finding body. He said it was ideally suited to make factual and legal judgments. So we then come to the scheme itself, and the only provision other than the tables that I was going to refer you to, you have been taken to, which is paragraph 16. Just to remind you that makes clear that the scheme recognises that there may be more than one descriptor that describes an injury. It says that where an injury may be described by more than one descriptor, the task is to identify that which best describes the injury and its effects for which benefit has been claimed.
Does that therefore undermine the Upper Tribunal's determination as to compulsion? Because if you've got a situation which is a subjective judgment on a subjective but specialist judgment on whether it's moderate or severe, obviously it can fall within one or the other. You've got to make the decision. But the word compel does seem to be rather inapposite,
Yes.
given the wording of the scheme. And you wouldn't seek to defend it from your reaction, Mr. Macur.
I wouldn't disagree with that description of it as being perhaps slightly infelicitous. There's also a phrase that my learned friend referred to where the tribunal said that once the first tier tribunal had found it was within B, that was the end of the matter. What I will say, as I come on to this, is if one looks firstly at the first tier tribunal's decision itself, it's very clear that's not the approach the First Tier Tribunal took. They recognised expressly that it was a difficult exercise to say which category Mr. Pearson fell into, but their judgment was that it was more appropriate that he was in the moderate category. And in the Upper Tribunal's decision, then the judgment also says that at other points. It begins by making very clear this is what the First Tier Tribunal's task was. We don't find any error in the approach. But then we do get those two paragraphs where they use the word compelling and the other phrase. But in my submission will be that doesn't mean that they took an impermissible approach. They found, in effect, that the First Tier Tribunal had appropriately recognised that what was important in this case was the regularity of work.
One way of reading the Upper Tribunal decision, though, is that it was a straight line determination, which is, do you fall within footnote B? If you do, we're not going to look anywhere else. Because you can be, you can, I mean, the First Tier Tribunal said, well, look, we're in between these two. And that was the nature of the decision, because neither of the parties were contending for a 1A. It was between severe and moderate. The First Tier Tribunal seemed to be rather taxed by where to land and express their difficulty. The Upper Tier Tribunal, one way of looking at the decision is that, you know, you start from the bottom upwards, and if you get to the features of footnote B, you don't go any further.
I'm not sure that's completely fair. I don't think the judgment, we'll come to this in a minute, that can be read as saying that you start from the bottom upwards. As soon as you find the one that matches, you stop. In my submission, what the Upper Tribunal is saying is that first of all, that they're not making a decision for themselves, they're reviewing the legality of the First Tier Tribunal's decision. And my submission will be that they're saying the First Tier Tribunal was correct because once regularity was established, that is the principal difference between these two categories.
Yeah, I see.
And in my submission, that is the difference. I don't accept the point being made that category A is about trajectory. We say the principal difference between the two is regularity, because that is the key difference in wording. And all the Upper Tribunal is saying is, well, once the First Tier Tribunal found that regularity was the key feature and regularity was present here, then that was the end of the matter. But I can't say that the wording is perfect. But then this court has said on many occasions that one isn't to judge tribunal decisions and lower court decisions with regard to that degree of rigour in respect of the text, as long as the substance of the decision is clear. Then in my submission it is, and they do make clear more than once in the judgment that it's a question of considering which is the most appropriate.
Yes, well, once we come to the decision of the Upper Tribunal, I wonder if you could address that paragraph that refers to the protean difficulty, because it doesn't seem to fit well with the rest of the judgment.
I don't disagree. It's not taken at its face. It's not completely consistent with what the Upper Tribunal has said elsewhere in its own judgment.
No, okay. Well, that might be the answer then. Thank you. Thank you, Mr. Macur.
So it's common ground, paragraph 16.1. The task is where an injury can be described by more than one descriptor to find out which best describes the injury. So we then come to Schedule 3, which contains the tables. It begins at page 114 of the authorities bundle. I'm not going to go through the other tables in any detail, but just to highlight that the approach taken is my submission, a pragmatic one, rather than one which is necessarily mathematical or indivisible. So, for example, to give you two examples, the first table, Table 1, which deals with burns, has, if you look at the first two headings, a distinction which, at least on my reading, it's quite difficult to see how you would have an injury which wouldn't be clearly within one or the other. It's very precise. So if you have a partial deep or full thickness burn, which is 70% or more of the body, it's item 1. If it's 69.9%, as it says in item 2, then it's item 2, regardless of whether it is partial deep or full thickness. But it is a very clear distinction, and it's quite difficult in that example, I think, to see how someone might say, well, probably are cases I can't envisage. But then table 2, for example, adopts quite a different approach, because table 2 deals with a whole variety of injuries. So it's very broad heading: injury, wounds, and scarring. And it's a long table, and in my submission, the predominant feature of that table is it is best described as full of examples. There are a lot of examples, and they're quite widely framed, and it's clearly the intention that it will be readily possible to identify where it goes, but it's different to the sort of dichotomy we see in table 1. Table 3, in my submission, is somewhere between the two. It is attempting to provide a scheme where one can say, well, this is in order of severity and will fall one side or the other of it, but it is in fact written in a way that doesn't purport to cover every circumstance. And the way I put it in my skeleton argument is that A1, 1 and 2, really the ones that we're looking at, cover paradigm examples, and it is then a matter for the Tribunal and the Secretary of State to decide where it best fits. So A1, which was introduced in 2019. So those, I've said those three because those three all deal with permanent mental disorders. So A1, page 126, covers a permanent mental disorder causing very severe functional limitation or restriction. Then item 1, those are the ones that we're concerned with, in terms of the descriptor, is in identical terms, except that it doesn't have the word very, and for some reason it doesn't have a comma, the word disorder, in the first example. And then the third, so item 2, again, it is in precisely the same terms as item 1, except that the word severe is replaced by moderate. There is no other difference at all between those, save for the comma, between those three descriptors. So the ones we're looking at, 1 and 2, in both cases it has to be firstly a permanent mental disorder, which is different to 3 and everything that's just below 3. So then we come to the footnotes, and as it's been said, that the footnotes are not themselves the descriptors. Page 127. It is in my submission worth looking at double A as well. So starting with double A, you have a functional limitation or restriction that is very severe, where the claimant's residual functional impairment, after, and there's various things that have to be done, adequate courses of best practice treatment, specialist interventions, and then judgment by a senior consulting, treating psychiatrist, it remains incompatible with any paid employment until state pension age. So to be within that category, you have to not be able to work at all in any paid employment. So even the day a year example would on the face of it take you out of the most serious category. It is confined to all of those being required. So you have to have had the best practice treatment and not have any possibility of any paid employment until state pension age. Looking then at the first point that I make about this is that if one looks at the first part of this, and there is some complexity here in light of other parts of the scheme. So it's a functional limitation or restriction where the claimant is unable to undertake work appropriate to his experience at the time of onset of the illness. I say that there's some complexity there because clearly the threshold that has to be passed is that you have to be in a position where you're not able to exercise your appropriate work. So in Mr. Pearson's case, broadly, that is not being able to work as a surgeon or as a treating doctor. Of course, the reason I say there's some complexity is that onset of the illness is defined elsewhere for other purposes as the time that you first seek medical treatment, but as this case demonstrates, the time that you first seek medical treatment, it may not be the case that you're unable to undertake work appropriate to your experience or qualifications. That may only become apparent or manifest itself later. But in this case, I say the answer to that is that it was accepted in the appeal proceeding on the basis that the appellant could not undertake work appropriate to his experience, qualification and skills. And then the analysis moved to the second part of the footnote.
Well, Mr. McNally, I just want to make sure I've understood this. You, I think, are reading the relevant words as meaning the claimant is at the time of onset of the illness unable to undertake work appropriate to experience, qualifications and skills. I just wonder whether the phrase at the time of the onset of the illness that doesn't govern the experience, qualifications and skills. In other words, the baseline is, as at the time of onset, what were the claimant's experience, qualifications and skills? Now, what is his or her position by way of contrast from that level? Yes, so I don't myself read it as meaning that you're not going to get into these footnotes at all unless you are immediately rendered unable to undertake work appropriate to your experience.
Well, that makes a great deal of sense. So in effect, putting a comma after illness. So it's comparing the work you can't do
yes.
with how you were before the onset of the illness.
Yes.
Yes, I can see that. That doesn't affect the point I was going to make about that, which is that I'll come on to that feature that you have the onset of the illness, and you also have a functional limitation, which means you can't undertake appropriate work, is in my submission the answer to paragraph 45 of the Upper Tribunal's judgment, where they say why they don't think that trajectory was important, because so in effect, once you've decided that he can't undertake work appropriate to his experience, qualifications, and skills, you then move to the second part of the analysis. I'll come back to that if I may when we look at the tribunal. But for the moment, the point I'm making is that there are two parts to both of these footnotes, A and B. The first part is a requirement that you are unable to undertake work appropriate to your experience, qualifications and skills. And that is identically phrased in both of them. If you are still able to continue your work as a surgeon, you don't get into these categories at all. So that's the first step for you to be eligible. The difficulty then is, well, what does "and over time able to work only in less demanding jobs" mean? The submission that the respondent places on that is that, as I've said, this is a paradigm case, and this is not someone who's in AA. This is not someone who is unable to do any paid employment until state pension age. This is someone who has some capacity for work. The paradigm case we say that this is concerned with is someone who can't undertake their regular job, the job for their appropriate experience and qualifications. But over time, they're able to work in less demanding jobs. So you may well have someone who has an injury. They can't work in the job that they're trained for. But over time, they can find other work. It might be intermittent. It might be occasional. There might be quite a gap between them not being able to work and finding that employment. But they fall into that gap between someone who can't work, who's assessed as not being able to work at all until pension age. But equally, I'll come on to, they're not someone who actually is in regular work. So we say that's the difference that's intended there. It's not saying that this is someone who can only work in, as the added word is said to put in, increasingly less demanding. Less demanding in this context doesn't mean it's in both A and B. It doesn't mean less demanding as in less and less demanding. It just means less demanding than the work that they're trained to do.
But what if the person who, on the face of it, is within A has had some less demanding jobs which in themselves amount to regular employment?
Well, if we're looking at B, you would ask yourself, is this person able to work regularly in a less demanding job? It can't be fatal that they may have moved jobs, may have moved jobs to a better job. The question is, are they able to work regularly? Whereas in my submission, the natural meaning of A is that this fills a gap between someone who can work regularly and someone who's not able to have any paid employment until state pension age. So it's someone who may not be able to work now, for example, but might be able to work in the future. It's someone who perhaps is working now, but couldn't for a period. It's perhaps someone who is working now, but won't be able to work again for a period because they're only able to work for periods of time. And that, in my submission, is the essential contrast with B, which is someone who, not in the job that they're trained for, but in a less demanding job, they can do that regularly, whatever regularly means.
So doesn't that go back to the trajectory point, which is assuming that somebody is able to reach their end point, whatever level, 1, 2, well, it wouldn't be 1, but 2, 3, 4, or 5, that would, providing it looks to be an ongoing situation, fall within moderate. But if you're looking at someone who's obviously tumbled through the scales, then this does fit in with the less demanding jobs. And whether or not they're... the difficulty that I have, Mr. Macur, in seeing regular as being so determinative of the level at which someone is placed, is that the regularity could relate to a very, very much more undemanding job, you know, taking an extreme, so that Mr. Pearson, who's gone from performing ear, nose and throat surgery, all of a sudden finds that the only thing that he could do was perhaps to, I don't know, become someone who takes round cups of tea to those who've had the surgery. But he can do it every day. I mean, that surely would mean that, you know, your example of the paradigm case because it was regular, wouldn't that result in a very unjust situation?
Well, in my submission, there is a degree of, if not injustice, at least, I think, arbitrariness, I think was the word used by the Court of Appeal previously. And that's perhaps not fair as a criticism, because the point of this scheme is it's a simple scheme, but it also covers a large variety of situations. So if I can perhaps give you a very straightforward counterexample. In Mr. Pearson's case, he can work 1 day a week, every week, so 50 days a year or so on. He would be in the same bracket as a comparator who could work 4 days a week in the tribunal, but not be able to work as a surgeon. There's clearly a significant difference between their earnings, between the position that they're in, but that is the nature of the scheme. And the difference in my submission that the scheme draws is, well, is this someone who can work regularly, or is this someone who we're not able to say that they will never work, but it's just that over time they can perhaps work in less demanding jobs, but we can't say that they can do that regularly.
So regardless of the degree of the fall, you're saying as long as there's regularity at the end of the day, that's the trump card.
I say that's the key distinguishing feature.
Yes, but do you say it's the trump card to get to the stage of the upper tribunal saying compelled to put the case in moderate rather than severe?
Well, one of the reasons that I say that the word compelled is unfortunate but not fatal is that in practice, if someone can work regularly, and by regularly, you have to build into that what the tribunal discussed. So if someone can work 1 day a year, technically that's regularly, but that's clearly not what is meant. There is a de minimis level and so on. But if someone can work regularly, this will be the most appropriate part of the scheme.
So in a scheme that's supposed to be simple, the veterans organisation knows that once a year shouldn't be considered regular, even if it is spot on 1st of January every year. This is what happens. And therefore, where do they draw the line? Somebody's working once a month, that's not enough. But somebody who's working once a week in whatever job isn't. I mean, somebody who's working 3 times a year in a less demanding job, whatever the level of the fall, you're saying it would be regular?
It would be regular, and I mean, that argument was made in tribunal on by, in fact, Mr. Pearson, to say, well, this isn't enough to be regular, and it's not a point that's on appeal. My answer to that is that it is a matter for the specialist judgment of the tribunal, but it will recognise that it's not a one-size-fits-all, but it is one-size-fits a lot of people in different situations.
And last point, if I may, on this particular topic, do you accept, therefore, the ground of appeal, which is to the effect that regularity may or may not be present, but it should not be the sole determiner?
I think I've said in the skeleton that it wasn't used as the sole determining factor.
I know, but I'm asking now, not outside of this,
I see.
this case. Do you accept the point that whether or not regularity is present, it should not be the sole determiner of moderate or severe?
I would say it's the key determining factor. I'm struggling to imagine circumstances where someone can work regularly, but can say that A will be more appropriate than B.
Well, for example, and I'm going to be very, very extreme.
Yes.
If a consultant surgeon who felt that they must work for their own sense of well-being was only able to collect glasses in a pub, I mean, he can go every week or every fortnight, but it doesn't seem to fit the bill there, does it?
but the judgment of those, as it comes back to the point that the Court of Appeal made in Duncan, that the judgment of those who wrote the scheme is to be respected, and when the tribunal, indeed the Secretary of State, is making these decisions, they shouldn't interpret these footnotes in a way that's against the natural reading because they don't think it results in an adequate amount of compensation. So based simply on those facts without any more information that would otherwise make A, for example, more appropriate. The fact that it may be collecting glasses in a pub would not in principle make any difference.
Well, I must say, I'm bound to question that, Mr. Merrington. I understand perfectly that the scheme aims to be one which can be administered comparatively easily, comparatively quickly. Therefore, it's necessary to take a broadish brush, and there'll be difficult cases around the margin. Is once a month regular for this purpose, or isn't it? But surely, the primary duty of the decision maker is to determine which descriptor is the more appropriate. And surely that means that if, in the sort of extreme example my lady is suggesting, the primary decision maker steps back and says, well, frankly, it's absurd to suggest that this person has only suffered moderate injury. He can do a tiny fraction of what he used to be able to do. And even that, it costs him a huge effort, and he can only do it with great difficulty. How can the footnote dictate that the decision maker has to depart from the primary duty of picking the most appropriate descriptor?
I understand that point. I mean, I'm reluctant to give any firm submissions on hypothetical facts.
No,
it might be that the tribunal would receive an argument that, well, something that's so completely removed isn't less demanding. It's an altogether different sphere of work. There might be scope for another, but I am reluctant to deal in hypotheticals. But the sort of rough and ready nature of the scheme is evident from elsewhere. I mean, the table 1, for example, it would appear that someone with a partial burn, over 70% of their body, would receive more than someone with a 69.9% full thickness burn.
I'd be very surprised if any tribunal found medical evidence that somebody had got 69.9%, but there we go.
One would hope that there would be appropriate argument, but it's...
There might be some discussion outside the door of the court, one imagines.
There might indeed. But it is a scheme which will result in apparent or perceived unfairness, in the sense that these categories include a lot of cases which are different from each other. And as I say, the obvious example here is one can well see from Miss Pearson's perspective, you can only work 1 day a week in the tribunal. I don't know whether my lady would have the same concern about the interpretation if this was someone who was working 4 days a week in the tribunal instead of being a surgeon.
Well, I think it would depend on the conclusion I come to on the trajectory point, because I do think that it's something that is very much to the front of a consideration to be made, given those words used. Accepting my Lord's point that the footnotes cannot possibly in any way displace the duty of the decision maker to determine what is the most appropriate descriptor. They may be assisted. Perhaps one of the complaints is that in this case the footnotes took very much more precedence over the descriptor than they should have done. But looking at severe and moderate in those terms, and the difference, of course, between the tables is that it's quite easy, isn't it, to say, in one sense, the physical injury is more readily defined by objective evidence than is the degree of severity of a mental illness, which the footnotes permit a subjective appraisal of ability to work in a particular level of job. But I'm not sure what the answer is, but you know, you're here to make questions and I'm not supposed to answer them, I suppose.
I'm not sure in that case this is a distinction that causes difficulty, because although I agree as a matter of generality that with mental health it can be more subjective, in this case the facts are quite clear. There's no dispute by anybody that Mr. Pearson can work 1 day a week. There's no suggestion that that's going to change. The first year tribunal said it was steady and regular, but there's no suggestion equally he could do more than that. We have the facts. It is, in my submission, a case of applying it to the scheme.
And there's no suggestion, is there, Mr. Mankell? And I'm sorry to override you here, but there's no suggestion that Mr. Pearson is deliberately downplaying his ability to do anything but that which he does, which is very important nevertheless. But he's showing or attempting to demonstrate to us the level of dissent.
I'm very happy to. There's absolutely no suggestion.
And of course, I'm a great supporter of judges. That's not to put them in any lower level. It's just the difference.
There's absolutely no suggestion that there's any downplaying or anything of that sort. This appeal is defended simply on the basis that the Secretary of State considers that the initial decision was correct and was upheld appropriately by the tribunal. There's nothing more to be said than that. I mean, if the tribunal has erred, then so be it. But in my submission, although it is right that the tribunal, of course, has to find the most appropriate descriptor rather than the most appropriate footnote, and I've said that in our written argument, nevertheless, the footnotes, when they're clear, represent part of the scheme and should be applied. And there is nothing else in my submission that tells you what moderate or severe means. There's nothing on the face of this scheme that's inconsistent with moderate, including someone who can work 1 day a week in a responsible and difficult job, albeit not the job that they wanted to do and were trained to do, saying that is moderate, whereas if Mr. Pearson was not working regularly but had some possibility of work, that would be severe. And that in my submission is how the scheme is interpreted. The first tier tribunal did get it right, and the Upper Tribunal appropriately found that there was no error.
What is the legal status of the footnotes?
They are part of the table, as I understand it, and there's no. In terms of the legal status, the entirety of this document is the statutory instrument.
Yeah.
It's all part of the statutory instrument. I'm not sure it's perhaps a question of legal status rather than in terms of function. And if the function of the descriptors is to tell the decision maker what categories to put an injury in, and the purpose of the footnotes, the function of the footnotes, is to help them to make that decision.
And we have, in the criminal procedure rules, we have footnotes, which are just explanatory. They're not part of the rules. I ask in a spirit of genuine inquiry. And the footnotes obviously only apply to people who, well, so it would appear to me, only apply to people who were in work at the outset with certain qualifications and so forth, and now because of their mental disorder can't work either at all or not regularly. So this is just, I mean, there must be, because the scheme can apply to people who've left the service, Or do they have to still be in the service when they apply?
It has to be attributable to service.
Yeah, well, I follow
But
that.
I'll be corrected if I'm wrong. I don't think there's any reason why they might not, for some
Yeah.
reason, have left service. And more broadly, you're right in that I don't say that every possibility is covered by
No.
this description. There could well be someone who has a severe injury or a moderate injury that doesn't naturally fall within either of those footnotes, but it's plainly a severe or moderate injury. But what I do say is that where there is a footnote which is applicable and where it appears to be relevant to the particular case, then the tribunal is right to seek to apply that footnote in order to make its decision.
Just looking at the time, Mr. Macur, you're obviously under no pressure, but can you assist us with roughly how long you think you're likely to continue your submissions?
I would have thought probably 45 minutes, something of that order.
Okay. Well, we'd better rise then, I think, for the next hour. And with thanks to all, we'll resume at 2 p.m.